Good morning and welcome to Defense Diaries. I am your host, Bob Mata, and this is my beautiful, brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all. Slightly distracted. I'm trying to score tickets for a concert, but I'm with you. I'm with you.
Wow.
There are 217 people ahead of me, so I'm just standing by.
Standing by. Trying to score some jacket tickets, my morning jacket. They're doing a 3-night run hometown show in Louisville, Kentucky. So that's right before Jazz Fest, though. Makes me nervous. It's a lot of away time. Makes me very, very nervous. So welcome to our continuing coverage of the Karen Reed case today. I got a nice surprise in the inbox that the Supreme Judicial Court's ruling on the appeal by Karen Reed's defense team is coming down this morning. I've got it in front of me. I'm looking at it, and we are going to go through it. It should be interesting. So if I remember correctly, I think the primary thrust of this particular appeal was that we had that whole issue with the jury, right? And wherein they had it on good authority from several of the jurors that they had reached an actual verdict on the second-degree homicide, but that they didn't understand the instructions, and that ultimately they ended up coming out and saying, well, we're deadlocked on everything. And then you have the situation where Judge Bev doesn't ask them, count by count, if this means that they're deadlocked on all counts. So it's really interesting. I'm really interested to read this. So let's start digging through it. And like before we got on, Allie's like, you know what? I kind of hate that we don't tell people what the result is right away and then go through and explain it. And I agree with her. There's no reason to torture people for 2 hours reading through a document to get to the end. The nice thing about appeals and Supreme Court decisions is they tell you right away what their decision is, and then they'll go through their reasoning behind it. So we'll find out right away what the deal is. So let me pull this bad boy up. Now, babe, you're going to have to read with me. I'm not reading.
All right, I'm about to purchase best available. I don't know what to do.
Sounds like a real Allison problem. All right, let's see. Okay, we got it up. Okay, so here we go. You guys ready for this? You ready? I screwed up and said,
"Oh my god, bullshit!" It said no longer available.
All right. Well, you tried. That's good. Let's move on.
No, I'm not done. Hold on.
What? This is outrageous. Okay, so the defendant challenges the denial of her motion to dismiss after her first trial ended in a mistrial. And then we have a footnote down here. Although Karen Reed commenced this action by filing a petition in the county court for convenience, we refer to her as the defendant. Okay. The trial was lengthy, spanning 8 weeks of evidence involving 74 witnesses and had 657 exhibits. The defendant does not contend that this evidence was legally insufficient to support a conviction on any of the charges, which would preclude retrial. Instead, her argument focuses on whether the trial judge properly declared a mistrial and the relevance, if any, of post-trial accounts of jury deliberations. The jury deliberated for 5 days, sending progressively insistent notes to the judge about their inability to reach a unanimous verdict. In their third and final note, the jury stated that, quote, some members firmly believed that the evidence surpasses the burden of proof establishing the elements of the charges, end quote, while others did not. They described their views as rooted in, quote, sincere adherence to their individual principles and moral convictions, end quote, and stated that further deliberations would be, quote, futile, end quote, and would, quote, force them. Oh, we had a second footnote. The record submitted to the single justice and now before this court does not contain transcripts of the testimony or the exhibits from the defendant's first trial. It's good to know. And would, quote, force them to compromise these deeply held beliefs, end quote. Based on this final note, the judge declared a mistrial. So the defendant's motion to dismiss and this petition rely on post-trial accounts from several jurors. These accounts suggest that during deliberations, the jury unanimously agreed that the defendant was not guilty on 2 of the 3 charges and were deadlocked only on the remaining charge. The defendant argues that a mistrial was thus not manifestly necessary because the judge could have requested a partial verdict from the jury before discharging them. The defendant further asserts that these post-trial accounts show she was, in effect, acquitted of 2 charges and that double jeopardy bars retrial on those counts. So that's the thrust. That is the absolute thrust of this appeal right there in a nutshell. How's it going, babe? So this petition thus
Oh, I'm giving up. They said we'll try again tomorrow. I had them. I got so excited, and then it's like tickets are gone. Then I had them. Tickets are gone. The hell,
the
bastard.
pre-sale probably only has a very small amount available.
Yeah, well, then they skyrocketed the price from $78 till then. I'm like, they're $211 each. And Amber
What?
said,
Yeah, no, not doing that. I'm not doing that. Is it the Rolling Stones you're trying to get tickets for? That's outrageous. $211. See jacket.
How did it know? But how did they hike them up in the middle of a pre-sale? They started at 78. Amber got 4 at 78 on the orchestra level. Oh well. So they haven't given us the ruling yet. They're just giving us background.
I think they will. So I think they're gonna they're giving us a little bit of background.
All right.
Okay, so this if I promise if we get into the meat of it and it doesn't give us the answer, we'll go to the bottom. We'll read it. And then we'll go back, obviously. So this petition thus raises the question: can post-trial accounts of jurors' private deliberations that are inconsistent with their public communications in court render the declaration of a mistrial improper or constitute an acquittal, where the jury did not announce or record a verdict in open court? We conclude they cannot. There's your answer. Okay, so that's it. All right, take care, everybody.
Bye.
All right, so let's see the rationale. So right there, denied. The count stands. The Commonwealth, if they so choose, which I still think is a major mistake for the Commonwealth, can move forward on the second-degree homicide charge, which I just think is a big mistake. It really is. No, we were kidding, Kathy. We're not dipping. I mean, that's the opposite of what we do. We're going to try to understand it. We're going to try to understand the rationale. That's the nice thing about appellate decisions and Supreme Court decisions, they give you, unlike Judge Gull, they give you their reasoning as to why they've ruled a certain way, and they're going to be very, very
right. Isn't there a part about whether they should have allowed to question the jurors? But I guess if the answer is no, then there's no reason to ask the jurors.
Yeah, like I'm assuming that they're going to get into that because I think that was in the brief. Okay, so the jury clearly stated during deliberations that they had not reached a unanimous verdict on any of the charges and could not do so. Only after being discharged did some individual jurors communicate a different supposed outcome, contradicting their prior notes. Such post-trial disclosures cannot retroactively alter the trial's outcome, either to acquit or to convict. Accordingly, we affirm the trial judge's denial of the motion to dismiss and the defendant's request for a post-trial jury inquiry.
Footnote 3.
Footnote 3. Let's go down and see what it is. The motion filed by the American Civil Liberties Union of Massachusetts, Inc., seeking leave to file an amicus curiae brief. It's hereby allowed. So they've granted the ACLU of Mass leave to file an amicus, amicus, whatever you want to call it.
Which did them no good, as it is still denied or affirmed.
Yeah. Okay. So here, you start reading the background a little bit. You do. We'll alternate every 2 pages.
Okay. Trial deliberations. In 2022, a grand jury returned 3 indictments against the defendant: murder in the second degree, which was count 1, manslaughter while operating a motor vehicle under the influence of alcohol, count 2, and leaving the scene of a personal injury resulting in death, count 3. Trial began in April 2024 and lasted over 2 months. Man, I forgot it was 2 months. Wow.
It was long. It was long.
On the 37th day, the jury received instructions regarding the 3 indictments and 2 lesser included offenses for count 2, involuntary manslaughter and motor vehicle homicide. Before deliberations began, the judge indicated that the foreperson of the jury would be given separate verdict slips for each of the 3 indictments. The judge then explained the procedure for delivering the verdicts. Quote, after the full vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdict to the court. The judge also instructed the jury to, quote, continue deliberating until you have reached a final verdict on each charge, and to not disclose their numerical standing or progress to anyone, including the judge, quote, before such time as you have reached a unanimous verdict, end quote. The jury then began deliberating. 3 days later, after approximately 19 hours of deliberation, the foreperson submitted a note to the judge, first note, that stated, quote, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. After reading the note into the record, the judge requested argument from the parties on whether the jury had conducted, quote, due and thorough deliberations, warranting a so-called Tui Rodriguez charge. Footnote 4. And
Do you want to read?
They quote the case, Rodriguez and Tui, and indicate the Tui Rodriguez charge is a model instruction given when jurors report deadlock after due and thorough deliberations. That is designed to urge the jury to reach a verdict by giving more serious consideration to opposing points of view. And now they cite Carnes for that. Once a deadlocked jury receives the Tui Rodriguez charge and resumes their deliberations, they shall not be sent out again without their own consent.
Shall. Big shall.
No, go down.
Oh.
The Commonwealth argued that the jury had not deliberated long enough, while the defense disagreed, requesting the instruction and asserting that the foreperson's use of the word exhaustive suggested an impasse. You go, babe.
Okay. The judge determined that further deliberation was appropriate and instructed the jury to continue. Deliberations extended through the afternoon and resumed the following Monday morning. At 10:45 a.m., the jury foreperson submitted another note to the judge, second note, which stated, quote, "Despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind." I guess there should be an end quote there. So, quote, "The divergence in our views are not rooted in the lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implication it holds." So upon receiving this note, the judge again invited argument from both parties. The Commonwealth acknowledged that the jury had already deliberated, quote, "in the vicinity of 22 or 23 hours," end quote. And footnote 5, although the transcript does not state the precise time that deliberations resumed on Monday morning, based on prior proceedings, it appears the jury had deliberated closer to 24 or 25 hours by this point, but nonetheless argued it was premature to conclude their deliberations had been due and thorough. So defense counsel, however, maintained that the jury were, quote, "hopelessly deadlocked," end quote, and again requested the Tui Rodriguez instruction. The judge agreed with defense counsel, noting that the jury had been, quote, "extraordinary," end quote, and that she had, quote, "never seen a note like this," or wait, was it never seen a note like this reporting to be in an impasse, end quote. The judge then delivered the Tui Rodriguez instruction to the jury and sent them back to deliberate further. At approximately 2:30 p.m., the foreperson submitted yet another note to the judge, third note, which stated, "Despite our rigorous efforts, we continue to find ourselves excuse me, at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs," end quote. So after receiving the third note, the judge informed counsel that, quote, "the jury is in an impasse." The jury were called back into the courtroom, and this is where it gets interesting. Like, this is where Allie and I, when we were watching this thing go down, like there were, and there was that argument about whether or not there was time for the defense to have her inquire, which the rules allow for her to do, to inquire as to whether or not they had reached a verdict on each and every count, or if this was pertaining to each and every count, to clarify, and they didn't do it. And you and I had both been concerned about whether or not that would be considered a waiver of the issue. So let's see if the court addresses that. All right. So stating that further deliberations would, quote, "force the jury to compromise these deeply held beliefs," the judge addressed the jury saying, "I am not going to do that to you folks," and declared a mistrial. The judge then discharged the jury back to the deliberation room, explaining that she would meet them there privately to thank them for their service. Pick it up, babe.
The judge and the parties remained in the courtroom to discuss their availability for scheduling a status conference on the matter. At no point during this discussion did defense counsel object to the judge's declaration of a mistrial or express disagreement with that outcome. And I'll just note that's why the court pointed out that the judge said, "Hey, jurors, stay. I'm going to come talk to you." So, and they did that for the purpose of, hey, they were all there. and nothing was said.
Right.
Right. Two.
Which is what we were concerned with. I mean, it's like we were talking about. If we have an objection, we don't wait for the judge to ask us if we have an objection. We make it, or if we have a request that we think is just critical, you ask it.
Right. And the defense's position was that once she says the words mistrial, no objections help anyway. It's been declared. So, all right, 2, post-trial events. According to affidavits submitted by defense counsel, a member of the deliberating jury, Juror A, contacted defense counsel on July 2nd, 2024, after noticing, quote, inaccurate reports about the jury's alleged, quote, split that caused the mistrial the day before. Juror A stated that the jury had unanimously agreed that the defendant was not guilty of count 1, murder in the second degree, and count 3, leaving the scene of a personal injury resulting in death. 2 days after the mistrial, the defense counsel also received screenshots. Footnote 6, a screenshot is a copy of an image displayed by a computer screen. All right. 2 days after the mistrial, defense counsel also received screenshots of a text message exchange with jurors of their acquaintances describing the deliberations. In one exchange, another member of the jury, Juror B, wrote, "It was not guilty on second degree and split in half for the second charge." Footnote 7. A month later, Juror B contacted defense counsel to confirm the content of this exchange and further asserted that the jury had unanimously agreed the defendant was not guilty of 3 as well. In another exchange, an individual referred to as an, quote, informant by defense counsel was advised that another Juror C, had told friends there was, quote, no consideration of murder in the second degree, and that the jury deadlocked on, quote, the remaining charges. These exchanges contained no mention of count 3, but it stated that, quote, manslaughter started polling at 6-6 and then ended deadlocked at 4 no, 8 yes. Juror C had also reportedly stated that the jurors had a, quote, a group text going. Upon receiving this information, the informant commented, quote, if they all agreed on no for murder 2, they should have made that clear to the DA and the court. It's basically a case of double jeopardy if she is retried on that charge. On July 8th, 2024, 1 week after the mistrial, the defendant filed a motion to dismiss based on these post-trial accounts. The defendant argued that the accounts showed that the juror effectively acquitted her of counts 1, murder in the second degree, and 3, leaving the scene of a personal injury resulting in death. She further contended that the judge's mistrial declaration was improper for these 2 counts and requested, at a minimum, a post-verdict inquiry to confirm whether the jury had agreed she was not guilty of those charges. Defense counsel later supplemented the motion with accounts from 2 additional jurors. One, Juror E, stated that the jury had been deadlocked only on the lowest charge on count 2. The other juror, Juror D, stated that the jurors' disagreement solely concerned, quote, count 2, and its lesser offenses. Your turn, babe.
Okay. Hold on. I was trying to make this banner real quick.
All right, I'll go. Juror D indicated that the jury had debated whether to inform the judge of their decision on counts 1 and 3, but they were uncertain, quote, if they were allowed, end quote, to do so. Juror D claimed that after discussing the matter, the jury ultimately decided to inform the court that they were deadlocked, and they expected they would get further instructions about remaining decided counts thereafter.
Oh, sorry. There we go. I got that. Do you want me to pick it up or you want to keep going?
I'll finish this page.
Okay.
The Commonwealth also submitted a post-trial filing notifying the court that after the submission of defense counsel's affidavit, it received 2 voicemail messages from a member of the jury. The jurors specified that the jury had voted not guilty on counts 1 and 3, as at least half, quote, and as of last vote, 9-3 guilty on the lower level manslaughter charges, end quote. The Commonwealth also received email messages from 3 individual jurors who identified themselves as jurors and asked to speak anonymously. Once the Commonwealth informed them that it may require to disclose the substance of their communication to defense counsel or the court, however, the jurors declined to communicate further. The trial judge denied the defendant's motion to dismiss after a non-evidentiary hearing. The judge reasoned that, quote, because there was no open and public verdict affirmed in the open court rendered in this case, the defendant was not acquitted of any of the charges, and the post-trial voir dire of the jurors would involve an impermissible inquiry into the substance of the jury's deliberations.
Additionally, the judge rejected the defendant's argument that declaring a mistrial was improper. She noted that defense counsel had twice requested the Tui Rodriguez instruction, quote, the final step, end quote, preceding a mistrial, and raised no objections nor made any request to be heard when the mistrial was declared. The judge remarked that, quote, defense counsel were no shrinking violets, end quote, during the trial, making it unlikely that, quote, when counsel heard that the jury was at an impasse for a 3rd time and a mistrial was inevitable, and perhaps the most crucial point in the trial, counsel would sit silently if they did not consent to a mistrial, end quote. She also concluded that in any event, the mistrial was manifestly necessary given the jury's repeated statements of deadlock. On September 11th, oh, wait, did we read footnote 8? Did you read that?
No.
Where was it? I didn't see it. Ooh. Oh, there it is. So on September 11th, 2024, the defendant filed a petition for relief under GLC 211, Section 3 in the county court. Okay, now that footnote says, although a defendant ordinarily is not entitled to interlocutory review of the denial of a motion to dismiss, we have recognized a narrow exception to this general rule in the context of double jeopardy claims. And see Neverson versus Commonwealth. The Commonwealth does not contest that interlocutory review is appropriate in the circumstances of the instant case. So a single justice of this court reserved and reported the matter without decision to the full court. And we've got another footnote 9. At the time that this matter was reserved and reported, the defendant's retrial was scheduled to begin on January 27th of 2025. The retrial has since been continued until April of 25. Discussion. So they're going to get into the meat of the matter here. This is where they're going to start digging in. So the proprietary of declaring a mistrial. The double jeopardy clause of the 5th Amendment to the United States Constitution, quote, generally precludes the Commonwealth from trying a defendant more than once for the same offense. And that cites Commonwealth v. Phim. And then they go into C. Benton v. Maryland, a federal double jeopardy clause applicable to the states by the 14th Amendment. However, an exception to this general rule applies when a mistrial is declared due to manifest necessity, end quote. And again, the citation was omitted. And then Ray v. Commonwealth, in such instances, the double jeopardy clause does not bar the state from retrying the defendant. See id. To determine whether the declaration of a mistrial is manifestly necessary, a trial judge balances the defendant's valued right to have his or her trial completed by a particular tribunal against the interest of the public in fair trials designed to end in just judgments. In Commonwealth v. Edwards, a hung jury has long been recognized as a traditional example of, and we had a footnote. Where did I miss 9? Where's footnote 9?
It's all the way at the top, first sentence.
Oh, okay. So footnote 9 was after. Did I read that already? No. At the time this matter was reserved and reported, the defendants. Oh yeah, I did read that. Never mind. Okay, a hung jury has long been recognized as, quote, a traditional example of manifest necessity, allowing retrial without offending the defendant's double jeopardy rights.
Now, if you remember, I was a huge proponent of them asserting that there was insufficient evidence, and it would, in essence, violate double jeopardy for those grounds. There was some other law or loophole that seemed to allow that avenue of argument and to appeal before being retried, but they never raised it.
Right. I mean, to me, like going back, like no matter what the timing of it was, whether it was before she declared the mistrial or not, I mean, there was opportunity for the defense to have asked. It's like, but in that moment, maybe you're just not thinking of it, because a lot of times you do consider as a defense attorney a mistrial to be a win in a way. I mean, obviously it's not best case scenario, but it's certainly better than a conviction. So, I mean, they could have in that moment been feeling like, okay, this is not the result we wanted, but it's a hell of a lot better than you being convicted. And I guess we'll see if they're going to take another shot, at trying you.
Well,
I mean, is it like, is that a
letter
hindsight 2020 type situation, babe? Like if we're sitting at the table and we're like, and you find out after the fact that they actually had read a verdict or rendered a verdict as to the second degree. And of course you're saying, God damn it, we should have objected or at least clarified whether or not, I mean, it's hard to say what you do in that moment.
Yeah, and it's also hard to imagine that was the case given the content of the letters, the notes that the jurors sent out.
Yeah. Yeah, the notes were, I mean, pretty well written. I mean, they sound lawyery, they sound like they were well thought out for certain. And I guess the question, I don't know if it was ever answered. I'm assuming that the foreperson would have read the notes after they were drafted and been like, all right, is everybody cool with this?
Oh, yeah.
I'll send it out, right? Okay, so jeopardy does not terminate when the jury is discharged because it is unable to agree. So the decision to declare a mistrial is entrusted to the sound discretion of the trial judge. Commonwealth v. Bryan. Trial judges receive such discretion to avoid the possibility of coercive measures being used to force jury agreement, thereby protecting the fairness of the proceedings. And that's C. Juvenile v. Commonwealth and Renico v. Lett. In evaluating whether a trial judge abused his or her discretion in declaring a mistrial, a reviewing court considers whether the judge carefully explored, quote, alternatives to a mistrial, end quote, and whether counsel were given a full opportunity to be heard. And that was quoted. Citation omitted, Commonwealth v. Taylor. So if these principles were followed, there is no claim of insufficient evidence to support a conviction. Double jeopardy will not prevent the defendant's retrial. Okay, so in footnote 10, what the hell was that? Did I read that as well? I can't remember.
No, because it says the defendant has not argued, and I don't know what the answer
Oh,
is.
it's right there at the end. So the defendant has not argued that the evidence presented at her first trial was legally insufficient to sustain a conviction.
Dude,
we do not.
Those words I literally just spoke.
What?
That I was trying to get them to argue that the evidence was legally insufficient. That was the other loophole around this. That's what I was screaming about, like when they first did this.
So in other words, you called it. Called it.
I hate.
Called it.
I
Wait,
hate people
I
do
know
that.
you hate doing that, but you just said, dude, I just said that like 2 seconds ago. So
Well,
do you really hate it, or
no, I do.
it?
Right.
Okay.
That's not.
Well, I love it. Called it. Nailed it. So here,
It's disappointing because I think it had legs.
yeah, I mean,
I tagged him in the tweet.
you did?
Yeah.
Wait, like back then?
Yeah. What are you talking about? I was like writing that really long
Oh, I
tweet.
remember that.
Right. And I think that was like when Trump got shot or something. Like, and I had been like working on this tweet forever. And I don't know, there was something else going on in the world, either something horrible somewhere. While I was like sitting at that crime con making this tweet and researching the law on all of this. And then you told me to tag him in it, so I did.
Well, apparently he didn't listen. To his own detriment. Who'd you tag you, Nettie? I think you would have tagged you, Nettie, probably.
Yeah.
So here we discern no abuse of discretion in the trial judge's decision that the jury were at an impasse and that a mistrial was manifestly necessary. After extensive multi-day deliberations, the jury submitted several increasingly emphatic notes about their inability to reach unanimous verdict. By the time the jury sent their first note, they had deliberated for approximately 19 hours over 4 days. That note stated that they had conducted a quote exhaustive review of the evidence, end quote, and given quote diligent consideration of all disputed evidence, end quote. Following the judge's instructions to continue their deliberations, the jury deliberated for another 5 to 6 hours, spanning a Friday afternoon and following Monday morning, before sending a second note that was noticeably more definitive. The note stated that the jurors were, quote, deeply divided by fundamental differences, and that, quote, a consensus was unattainable. Echoing language from other cases where we have characterized a jury's report of deadlock as unambiguous, end quote. So, C. Ray, 463 Mass, concluding the jury note stating that jurors were, quote, hopelessly deadlocked was, quote, unambiguous, end quote, about their inability to agree, Fuentes v. Commonwealth. So final note stating that the jurors were, quote, unable to come to a unanimous decision, end quote, unequivocally reflected that they were deadlocked. You're up, babe.
Oh, well, I still can't get over the fact that they didn't raise the insufficiency of the evidence argument. I mean, that might have actually made a difference. Whatever, you know.
Hey,
you live, you learn.
Can't all be you.
Can't all be me. Can't all be me.
Can't all be you.
Second note further emphasized that the deadlock arose from not from, quote, a lack of understanding or effort, but from, quote, deeply held convictions that each of the jurors carried, end quote. By this point, the jury had already deliberated approximately 24 hours. See footnote 5, supra. You don't want to go back. Do you want to go back up to it or no? I was just wondering if you wanted to revisit note 5, but I guess not. It's fine. The defense counsel described.
Oh, no, sorry, I was muted. No, we read it. Fuck that footnote.
The defense counsel described them as, quote, hopelessly deadlocked. But the trial judge did not immediately conclude that all hope of attaining a verdict was lost. Instead, she issued the Tui Rodriguez charge, a standard instruction that encourages deadlocked jurors to reach a verdict by giving more serious consideration to opposing points of view. Again, and that was probably what that same footnote was when they cited this Shalou. Or after nearly 4 hours of additional deliberation, bringing the total to approximately 28 hours, the jury submitted a third note that was even more emphatic. It stated that further deliberations, quote, would be futile and only serve to force us to compromise our deeply held beliefs. While there is no, quote, mechanical formula, end quote, for determining whether a jury is genuinely deadlocked, and they're citing some case law there, the trial judge acted well within her discretion in concluding the jury were at an impasse and a mistrial was manifestly necessary. The defendant contends that, despite the jury's deadlock, the trial judge failed to adequately consider alternatives to declaring a mistrial. Yet, as discussed, the trial judge did consider and pursue such alternatives. Well, what about all readily available alternatives? I mean, that's what they're arguing, not just like any old alternatives, but open and available ones.
Such as what?
Polling the jury.
I mean, it's not really polling the jury. It's like she had
Well, right, sorry, asking them if they were deadlocked on all three.
yeah, because people kept confusing polling the jury, which is a very specific thing, wherein you're asking each juror after they've rendered an actual verdict whether or not that is
now, and was
right.
this then?
Exactly, just because they do it individually just to make sure that no juror was bullied or forced into rendering that verdict, and that's their actual verdict.
Right, but she could have. I'm sorry, I misspoke. She could have asked them, is this on all? Have you reached a verdict on any of the counts, or
Which
unable to reach a verdict on all charges on all?
Because I read the rule and I posted that. I tweeted that rule that there's a definitive rule.
Yeah,
That she
has
the ability to do it, and like there was some people misreading it. And I mean the question is, like, I'm sure if you were to ask Bev, she probably would have wished she had done it. I mean, no one wants to do a retrial. Not the judge, not the lawyers, not the defendants, not the state. No one wants to do that shit. No one wants to do those things twice. So, I mean, if it could have avoided that, I'm sure if she could turn back the hands of time, she would ask the question. Where were you at?
Scroll up. I was right at the beginning of that. I think you're covering one sentence. Oh, wait.
No, I think you were right at the judge failed to adequately consider.
Yep.
Yeah.
Yet, as discussed, the trial judge did consider and pursue such alternatives. At the first note reporting deadlock, the judge instructed jurors to continue their deliberations. At the second note, the judge issued the Tui Rodriguez charge. It was only when the jury submitted their third report of deadlock, at which point the judge was statutorily precluded from ordering them to continue deliberations without their consent, cite to the statute, that the judge declared a mistrial. Nonetheless, the defendant argues that the judge should have inquired whether the jury had reached an agreement on any of the charges. Had the judge done so, the defendant asserts, she would have discovered that the jury had agreed on counts 1 and 3, allowing for a partial verdict. We disagree. All right. Well, let's see what they say. Rule 27B of the Massachusetts Rules of Criminal Procedure. This is the rule Bob was discussing. Gives a trial judge discretion to require a jury to return a verdict for charges on which they have unanimously agreed before declaring a mistrial. And they cite the statute and a case. The judge may, underlined may, first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. Rule 27D also permits a judge to poll the jury when a verdict is returned and before a verdict is recorded. However, a judge is not required to accept a partial verdict before declaring a mistrial, and is prohibited from doing so on a single indictment that contains lesser included offenses. So again, some of them did not include lesser included offenses, some did. So let's see what else the court said. Here, the jury were instructed on 3 separate indictments, along with 2 lesser included offenses on count 2. But the trial court record offers no indication that a partial verdict was imminent or possible. The jury's first note simply stated that they were unable to reach unanimous verdict without reference to any specific charge. The second note reiterated.
Wait, am I? Oh, yep. You wanted me to move on.
That consensus was unattainable and acknowledged, quote, the implications, end quote, of the jury's deadlock. Neither note suggested the jury had reached or could reach a consensus on any subset of the charges. I'm trying to put myself closer to the floor because I keep moving, which people really don't like. Try to plant my feet. Okay. I feel really low now.
Super low. The down low. The low.
Whatever. Okay. Go up. So I can start that sentence again. And
Okay.
then footnote. Okay. Neither note suggested the jury had reached or could reach consensus of any subset of the charges. And I'll go to note 11 in a second. And we have cautioned against assuming a final verdict exists from general reports of deadlock. Footnote 11 reads, as the trial judge observed in her memorandum of decision denying the defendant's motion to dismiss, it is particularly striking that the jury notes provided, quote, no inkling, end quote, of agreement on any of the charges. Additionally, the note did not request clarification on whether a partial verdict could be returned. This absence is particularly significant given the evident, quote, care that went into writing the notes and how articulately they expressed the jurors' disagreement, end quote. Good, babe.
In fact, the jury's third note implied that they were deadlocked on all underlined, for emphasis, charges. That note stated in part that, quote, some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of the charges, again, underlined for emphasis, beyond a reasonable doubt. Conversely, others find the evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. Again, emphasis added. And that's an end quote. Although the defendant relies on post-trial affidavits to suggest, quote, the charges, end quote, referred only to count 2 and its lesser included offenses, we assess the trial judge's decision based on what was known at the time of her decision. See Commonwealth v. Torres. As one court has observed, allowing post-trial juror accounts to affect the analysis, quote, would create endless confusion and controversy, end quote, in cases where a mistrial has already been declared due to deadlock. Fitzgerald v. Lyle. So in short, the record before the trial judge suggested complete deadlock, which I agree with. I mean, those notes, if you're reading them at face value, were pretty unequivocal and well written. Like, these weren't like moronic notes like, we can't make decisions. We don't know. What do we do? You know, it's like, I mean, they were very well written. The first,
which is why the defense was suggesting that it shows that they were confused about whether they could disclose that they had reached a verdict on some of the other counts.
right. So in short, the record before the trial judge suggested complete deadlock. The first and second notes provided no indication of a partial consensus, and the third note plainly implied the opposite. See State v. Fennel. As cases cited, quote, the mere theoretical availability of partial verdicts does not obligate trial judge to conduct further inquiry where, quote, no party has requested a partial verdict be taken or the jury does not indicate that it has reached one, end quote. Further still, these notes indicated that additional inquiry into the jury's deliberations risked producing a coerced verdict, which is always like the argument with dynamite charges or Tui Rodriguez charges, you know, whatever you want to call it, where you're forcing a jury to go back. You're always concerned with that. You're always concerned with somebody doing what one of the notes said that they didn't want to do, which was compromise on what their beliefs were in order to come up with a verdict. So judges must carefully avoid actions that might pressure jurors into compromising their genuine. Oh, never mind. Court said it. Into compromising their genuine views of the evidence. See Commonwealth v. Foster. And we have long recognized that, quote, deadlocked juries are particularly susceptible to coercion. and that's Roth, and then C. Commonwealth v. O'Brien, and cases cited, is precisely for this reason that judges are statutorily prohibited from ordering further deliberations by a deadlocked jury that has twice reported being at an impasse after due and thorough deliberation, unless they explicitly consent or seek clarification on the law. And that's C. Commonwealth versus Tisconi. Quoting GL, quote, if after due and thorough deliberations, the jury reports to the judge twice that they are deadlocked, they shall not be sent out again without their own consent unless they ask from the court some further explanation of the law, end quote. The risk of coercion is also heightened when a judge inquires about the possibility of a partial verdict following a deadlock, as we have explained, quote, where the jurors have twice reported themselves deadlocked and have already heard the Tui Rodriguez charge. A judge's inquiry concerning partial verdicts cannot avoid communicating to the jury the judge's desire to salvage something, emphasis added, from the trial. However, the inquiry is articulated or explained. The import of the inquiry is unmistakable. Quote, can't you at least decide a part of this case? End quote. The inquiry, by its nature, plays on the deadlocked juror's natural sense of frustration, disappointment, and failure. The jurors are confronted with the request and asked to absorb its inherent complexity at the worst possible time, when they are tired, anxious to be discharged, and perhaps angry at fellow jurors whom they blame for failing to reach an agreement, end quote. It's a fucking great language from that case.
Yeah.
Really breaks it down really well,
Yeah.
like what the issues are. So in this case, the risks of coercion were evident. After receiving the third vote, the judge was statutorily barred from ordering further deliberation without the jury's consent. CGL.
I just want to say there's a little bit of a difference here. They weren't suggesting like, well, do you think you guys could reach a verdict on this, like sending them back to try again type of thing? Where it could have been just a very casual question. Is this on all of the charges? You know, they could have worded it in a way that didn't raise all the concerns that the court just so clearly did lay out. And I definitely agree with that being an issue. But I also think there was a way to do it here that didn't implicate all of that.
Yeah. All right. Far from suggesting that consent might be obtained, the third note made clear that further deliberation would, quote, only serve to force the jurors to compromise deeply held beliefs rooted in, quote, sincere adherence to their individual principles and moral convictions. And then they cite Commonwealth v. Windbush. Statutory prohibition on the ordering further deliberation was designed to prevent jurors, quote, from being coerced into reaching a verdict in the face of views conscientiously reached and held, end quote. Asking jurors whether they would nonetheless consent to further deliberation would have implicitly pressured them to compromise those beliefs in order to, quote, salvage some part of the trial. And again, that cites Roth. In these circumstances, quote, there is simply too great a risk that any resulting verdict, quote, would merely be the product of one hasty final attempt to satisfy the judge's apparent desire for some form of decision on the case, end quote. And if the judge were to inquire about the possibility of a partial verdict, quote, by definition, any further discussion amongst the jurors regarding their response to the judge's partial verdict inquiry would itself be further deliberation in violation of the statute. Indeed, if the judge had inquired about a partial verdict on her own initiative and the jury returned a verdict of guilty on any of the counts, quote, there is no question that this defendant would be making a strenuous and potentially meritorious argument that the guilty verdict was a product of coercive intrusion into the function of the jury. And that, again, citing Roth, thus, given the entire course of jury deliberations and the emphatic language of the third note that the jurors were deadlocked on the charges and that further deliberation would be coercive, the judge acted within her discretion, declaring a mistrial without inquiring sua sponte about a partial verdict. Cifuentes. Judge was not required to ask a jury if they would consent to further deliberations before declaring a mistrial because the jury had already received a Tui Rodriguez instruction and final note unequivocally stated they were deadlocked. And that comes from Daniels. All right, you're up, babe.
For much the same reason, the trial judge's decision not to poll the jury sua sponte to confirm the deadlock before declaring a mistrial did not constitute an abuse of discretion. We explained in Ray, that's a Massachusetts case, polling jurors about, quote, whether further instruction or deliberation would be likely to resolve the deadlock is discouraged due to the, quote, risk of coercion inherent in questioning the jurors, particularly in individual colloquies, end quote. A trial judge is not, quote, required to consider every conceivable alternative before declaring a mistrial. I guess that goes to my earlier comment. And we discern no abuse of discretion in the judge not pursuing alternatives suggested after the fact by defense counsel based on information obtained after the mistrial was declared. They cite to Cassidy. If in that case, the part they cite is if an alternative which was neither suggested by counsel nor considered by the judge is later developed, we will not fault the judge so long as an honest inquiry into alternatives is made. Then they quote the Bluford v. Arkansas, for we have never required a trial court before declaring a mistrial because of a hung jury to consider any particular means of breaking the impasse, let alone to consider giving the jury new options for a verdict. The defendant further contends separately from the availability of alternatives that it was an abuse of discretion to declare a mistrial without first notifying defense counsel of the content of the third note and allowing an opportunity to be heard. First, it is worth noting that the trial judge discredited counsel's claim that he lacked such an opportunity, citing to Garner. Appellate court defers to the credibility determinations of trial judges. The judge explained that she had previously sought defense counsel's view after receiving each of the first two juror notes, when counsel had argued that they were at an impasse. The only alternative proposed by defense counsel during these exchanges was the issuance of the Tui Rodriguez charge, which the judge granted. When the third note prompted the mistrial, defense counsel neither objected nor expressed any dissatisfaction, even when the parties remained in the courtroom to schedule a subsequent status conference. Well, I don't think that that's very fair, because obviously the only suggestion they're going to make before a Tui Rodriguez charge is given is to give a Tui Rodriguez charge. Any suggestion that would come after that would obviously be different. However, the court goes on to say, in any event, there is no indication that inviting defense counsel to participate in a third round of, quote, consultation would have produced any fruitful alternatives. Citing again De Fuentes, as discussed, the receipt of the third note barred the judge from requiring further deliberations without the jury's consent, end quote, because they had already engaged in due and thorough deliberations and twice reported being deadlocked, quoting Carnes, or citing to Carnes. Furthermore, nothing suggested that defense counsel would have requested an inquiry into the possibility of a partial verdict based on the content of the jury's notes. Citing to Oliver in a New York case, having displayed... Keep going, babe.
Oh, sorry.
Wait, too much.
Oopsies.
Having displayed no enthusiasm for the rendering of a partial verdict while the jury was still impaneled, a guilty verdict still possible, the defense may not seek to overturn the court's order of a mistrial after the discharge of the jury. While the more prudent course might have been to read the third note to counsel and provide yet another opportunity to be heard before declaring a mistrial, the judge did not abuse her discretion in failing to do so. So I think it's clear what they're saying is like, look, you want to play now like you may have made some other suggestions, but we're all reading the same notes here. There was no real indication that it would have made a difference. And I don't think you would have asked for shit different had you been given the time, is the way I read this.
Yeah, I
ultimately.
I do too, and, like, but, in terms of, like, you talking about when the 2E charge was actually given, and I mean, like, the bottom line is there are 2 kind of distinct things that you're asking the judge to do. Like, you're not necessarily asking them in the inquiry as to whether or not they have actually reached a verdict. Just to clarify, just for clarification purposes, have you reached a verdict on any of the counts? Isn't telling them that you want them to go back and continue to deliberate. I mean, you're just asking it for clarification's sake, so, but I mean, if the answer is yes, I guess the follow-up question is, well, okay, to which count? And then they'll say, okay, well, second degree murder, we don't feel that the state's met its burden. And then I don't know if that would then that might potentially encourage the judge to say, well, you came back on that one, is there any way that you can go back there and continue to deliberate? Yeah, I don't know. I don't know.
So can you scroll up just a second? Because I missed footnote 12. Wait, not
Footnote.
that far, babe.
Well, I don't
There
I
you
don't
go.
see any other footnotes, bro.
I will just slow. Hey,
There it
can you?
is, sis.
I
Oh,
know, but
oh,
wow. Just
oh.
stay there a second so I can look. All right,
Oh, there it is.
it's the first sentence. So now scroll up one more second so we can see the full sentence. Okay. All right. So this is kind of what we were discussing before. Further, nothing suggested that defense counsel would have requested an inquiry into the possibility of a partial verdict based on the content of the jury notes. Footnote 12. It is difficult to imagine that a competent defense attorney, upon learning that some members of the jury, quote, firmly believed the evidence proved, quote, the elements of the charge, end quote, beyond a reasonable doubt, would request that the jury be instructed to return verdicts on any charges where agreement had been reached. As other courts have recognized, quote, a defendant may have a tactical reason for not requesting the trial judge to question the jury about a partial verdict, end quote. The trial judges should not be required to inquire about partial verdicts on their own initiatives.
So that's the pushback right there.
Right. And again, it's really focusing on the content of those notes wouldn't have based on that, uh, their argument that we might have done something different or we weren't given the opportunity falls on deaf ears because the facts don't suggest that a lawyer would have done so given the content of those notes. Okay, so in sum, scroll down. We conclude that the trial judge acted within her discretion in declaring a mistrial without first inquiring about a partial verdict or offering defense counsel an additional opportunity to be heard. Considering the length of the jury's deliberations, the judge's prior efforts to encourage consensus, and the increasingly emphatic tone of the juror notes indicating deadlocked, it was clear the jury had reached an impasse. And, the defense was making more of a legal argument that it required before the manifestly, erroneous can apply. Manifestly necessary um, element is applicable that they have the opportunity to be heard and that they do these things. And, here the judge is saying form over substance because if you would have gotten the opportunity, nothing different would have happened. Um, and I think it's on you.
Yeah, so Pokey had asked, this is a pretty it's happened actually a few times in the last couple of years that I can recall. I know it happened obviously with the whole Murdoch thing. They
Yeah,
got
and the quick answer to that is anytime that you're talking about things discussed in the during deliberations that were um not offered as evidence, like that something wrong happened in the jury room. Somebody presented information that shouldn't have been heard. They talked about something they shouldn't, you know, anything like that. That's when you bring the jury back in to find out what happened. What you can't do is bring them back in and say, "Did you guys consider this? What did you think about that? Did some of you look at this piece of evidence? What was your reasoning for your verdict?" Things like that. That you can never ask. And that's not what the defense here was seeking to ask. They just wanted to know point blank, did you reach a unanimous verdict on this issue? Not why, not what did you think about, not what did you talk about, not what did you consider, none of which is allowed. On the other hand, if you had a um like an expert, a physician or something like that in there, and the physician's like giving very specific medical information, not just like, you know, common type knowledge, but something that is known to this juror that was not presented as evidence that the jury considered. Well, then you all want to question the jurors. Did you guys, not even how did it affect you, but did somebody introduce evidence outside of what was presented?
Well,
Like,
that's
oh,
like what happened in Murdoch with Becky Hill. The clerk of the court is sitting in the, you know, deliberation room talking to the jurors when they're out on the field trip. She's talking shit. I mean, like that kind of situation. That inquiry has nothing to do with anything relating to the evidence per se. It has to do with whether or not they were improperly influenced by somebody that they are not allowed to be improperly influenced by. And I think that in like the Benefield case was another one where they had the jury come back in chambers though to discuss whether or not one of the jurors was tweeting out information or texting out information secretly to somebody in terms of the verdict was forthcoming and things like that.
and
So
I'm sure in turn whether that person was receiving information from outside as well, which
right.
would be of more importance to the verdict itself. Although I'm sure the judge wanted to know, possibly hold someone in contempt for that action as well. But as far as influencing the jury, once you hear jurors sending out information, now you want to know, were they also getting information?
Right.
Did they have a plan of, this is gonna be what my verdict is going in, all of those kind of things. So,
All right. Do you want me to pick it up?
yep,
Or we were at the top of the page.
I believe so.
All right. Furthermore, nothing suggested that the deadlock was limited to a specific charge. On the contrary, the notes contained no inkling of agreement. And the third note implied the jury were deadlocked on all charges. Emphasis added. Excuse me. Under these circumstances, given the content of the notes and the fact that defense counsel did not request further inquiry, engaging in one sua sponte risked coercing a verdict. Thus, the judge appropriately exercised her discretion in declaring a mistrial based on manifest necessity. See Daniels in cases cited. Judge did not abuse discretion in declaring a mistrial after 4 days of deliberation where the jury had reported an impasse and received Tui Rodriguez charge, but remained unable to reach a verdict and stated in response to judicial inquiry that additional deliberations would not result in a verdict. See also Fuentes, where no abuse of discretion declaring mistrial without further asking whether the jury would consent to deliberate further, where the jury had already been given the TUI instruction and the final jury vote unequivocally stated the jury were unable to come to a unanimous decision, end quote. And 13 footnote, because we conclude that the trial judge acted within her discretion in determining that declaring a mistrial was manifestly necessary, we do not need to address the defendant's alternative argument that the defense counsel did not consent to the mistrial. Similarly, we do not address the defendant's ancillary argument raised here for the first time that the court should have conducted a colloquy with the defendant before finding such consent. But see Daniels. So does that footnote continue? Oh yeah. That the defendant did not personally assent to the mistrial makes no difference. and that's Peretta v. Commonwealth. There can be no doubt that the federal constitution does not condition the permissibility of retrial on the defendant's personal explicit assent to a mistrial motion brought by his attorney. Okay, and then 2, defendant's claims of acquittal. The defendant separately argues that she cannot be retried on count 1 or count 3, regardless of whether the mistrial declaration was proper. She contends that post-trial information from 5 deliberating jurors, footnote 14, for purposes of adjudicating the motion to dismiss, the trial judge accepted that purported juror statements as true and accurate. For purposes of this discussion, we similarly proceed from the assumption that the affidavits are accurate. So indicating that the jury were deadlocked only on count 2 and had unanimously found her not guilty on counts 1 and 3, 15. And that is juror C did not disclose information indicating whether the jury had unanimously agreed that the defendant was not guilty on count 3. So effectively amounts to an acquittal of those counts. Alternatively, she asserts that the trial judge abused her discretion denying a post-trial inquiry to verify these accounts of juror deliberations. We examine each contention below. So contention A, claim of acquittal based on juror disclosures. The double jeopardy clause of the United States Constitution prohibits retrial for the same offense after an acquittal. See McElworth versus Georgia. To determine whether an acquittal has occurred, we look to whether, quote, given the operation of state law, end quote, the jury, quote, acted on their view that the prosecution had failed to prove its case, end quote. McElworth. So because this presents a legal question, our review of the trial judge's decision is de novo.
So that just means that they're looking at it on their own. It's not like they're giving the judge's, discretion to the judge's ruling. They're looking at the law on their own account, making their own decision.
Okay, so relevant here, sorry. I did a lot of screaming this weekend with my buddies in Tennessee, which, Pokey, is why I was still, whenever I travel to anywhere, I always adopt the dialect and accent from that area. So for the 5 days I was in Tennessee, I was speaking in a deep, deep country accent, which bled into my impersonation of a moron earlier in the live.
Boy. Lord, I think you just offended a bunch of people.
No, I was just speaking in my known dialect from the last 5 days. It had no impact on my thinking that people from the South are moronic. So, relevant here, the fundamental requirements for a jury's issuance of a verdict in a criminal case are set forth in mass. Pursuant to that rule, a valid jury verdict must be unanimous and returned by the jury to the judge in open court. So, our case law confirms that a criminal verdict is effective only when affirmed by jurors in open court. See a juvenile. And then quoting Lawrence v. Stearns, quote, the only verdict which can be received and regarded as a complete and valid verdict of a jury upon which a judgment can be rendered is an open and public verdict, given in and assented to in open court as a unanimous act of the jury, and affirmed and entered of record in the presence and under the sanction of the court, end quote. In other words, the distinction between informal, quote, agreement on a verdict, end quote, and the actual, quote, return, receipt, and recording of a verdict in open court is central. Only the latter constitutes a final verdict of the jury on a criminal charge. Juvenile supra, quoting Commonwealth v. Kalinowski, we have consistently reaffirmed this long-standing distinction throughout our jurisprudence. Footnote 16, lengthy, Commonwealth v. Tennyson. Initial verdict was, quote, sealed but not yet valid because it was not given and affirmed orally by the jurors in open court. end quote, polling of jurors after declaration of a mistrial in a murder case, showing that 11 had voted to convict the defendant of a lesser included offense of manslaughter and 1 had voted to acquit, quote, was of no effect and did not constitute an acquittal on so much of the indictment as charged murder in the first and second degree, end quote. So no final verdict where 1 juror died after jury had unanimously agreed to the verdict, but before the jury announced that verdict in open court. Wow.
Wow.
So no final verdict where the jury had come to a unanimous agreement, but where 1 juror changed his mind following morning when the jury met to return the final verdict. So those are some nice examples there. The dying juror ones. Whew.
Yeah,
All right. In this case, it is undisputed. Wow. It is undisputed the jury did not announce a final verdict on any charge. Although the defendant had submitted affidavits claiming the jurors reached an agreement on counts 1 and 3 during deliberations, the only statements made in open court reflected the jury's inability, emphasis added, to reach a unanimous verdict. So as discussed, the jury submitted 3 separate notes to the judge indicating deadlock, culminating in a final note indicating that, quote, some members of the jury firmly believed that the evidence surpassed the burden of proof establishing the elements of the charges, end quote, while others did not. You want to pick it up here?
okay. Far from an affirmation in open court of unanimous agreement on counts 1 and 3, citing the juvenile, these notes clearly reflected a lack of consensus on, quote, the charges. Even if the jurors' deadlock pertained specifically to count 2, their notes made no such distinction, nor did they indicate any verdict would be returned, quote, to the judge in open court, end quote, as required by Massachusetts Rule of Criminal Procedure 27A. In the absence of a verdict returned, received, and recorded in open court, we cannot conclude that the jury, quote, acted on their view that the prosecution had failed to prove its case, citing to Clark. And the quote there is, however fully it may be made to appear that the jury arrived among themselves at the decision that the defendant was not guilty, there is no claim that they agreed to so report or return, or that they agreed to report any agreement whatsoever, except that they could not agree. And footnote 17 indicates that the circumstances of Clark are very similar, and that's a Tennessee case, are very similar to those at issue here. There, the defendant argued that he had been acquitted at his first trial, after learning that the jury had agreed he was not guilty and had deadlocked only as to his co-defendant. Rejecting this argument, the Supreme Court of Tennessee explained, agreement, quote, agreement on the issues of guilt or innocence is of the very essence of a verdict, We have here no verdict reported and none agreed on and intended to be expressed. It is conceded here that the report of disagreement was that intended to be, whoa, go back up. I can't see anything. What, babe? We weren't in a footnote. We were like, okay. All right, here it is. It is conceded here that the report of disagreement was that intended to be, oh, you're right, it's a footnote. Okay, sorry. Reported. This determinative distinction runs through all the cases we have examined. And that's the conclusion of the footnote there. The defendant nonetheless argues that, quote, any lack of formality, end quote, in the jurors' intended dispositions of counts 1 and 3 should not prevent those dispositions from taking legal effect. However, the requirement that a verdict be returned and affirmed in open court is far from a mere formality. Rather, quote, these principles recognize that, as a practical matter, Jurors may agree in the course of deliberations to a tentative compromise on the facts of a case or on the disposition of related charges as they attempt to reach a unanimous verdict. Citing Floyd and which is a Massachusetts case, and then Bluford, the U.S. Supreme Court case. Since, quote, a jury should not be precluded from reconsidering a previous vote on any issue. And they're citing to Massachusetts case a juvenile. Tentative or conditional agreement reached amid deliberations, quote, cannot have the force of final verdict. Again, citing to juvenile, a jury should not be precluded from reconsidering a previous vote on any issue, and the weight of the full adjudication should not be given to any jury action that is not returned in a final verdict. I'm surprised that the court's not distinguishing juvenile on some of the other issues. No, scroll back up. Okay. Requiring a jury to publicly affirm their verdict in open court thus serves as a vital purpose. It ensures that the verdict agreed upon in private truly reflects the unanimous and deliberate judgment of each juror under public scrutiny rather than a tentative compromise. Maintaining this distinction between private deliberations and public verdicts is essential to preserving both the confidentiality of jury discussions and the integrity of the judicial system. Thus, because the jury did not publicly affirm that the defendant was not guilty of the charges, there was no acquittal barring retrial under the double jeopardy clause. Again, citing to juvenile. And there it was they had a signed verdict slip reflecting votes of not guilty found in the deliberation room after mistrial had been declared due to a deadlock, and that did not constitute an acquittal. They also cite to Commonwealth v. Mayfield information indicating that, quote, a jury was deadlocked 11-1 for conviction of murder, but only in the second degree, end quote, and had purportedly agreed that the defendant was not guilty of murder in the first degree, did not bar retrial because, quote, there was no open and public verdict of not guilty. So B, request for a post-trial jury inquiry. Finally, we consider the denial of defendant's request for a post-trial jury inquiry. Generally, a judge is not obligated to investigate jury deliberations unless there is evidence that the jurors were exposed to extraneous information or demonstrated racial or ethnic bias. So that's what Bob and I were talking about earlier. When can they, question a jury? Even in the cases of alleged bias, however, judicial inquiry cannot delve into the juror's subjective reasoning or deliberative content. And they say, see the matter of enforcement of a subpoena, Massachusetts case. Because the trial judge is afforded, quote, broad discretion in assessing whether a post-trial jury inquiry is appropriate, we review that determination only for an issue of abuse of discretion. So again, that's the difference of before they said this is a legal issue. We're going to look at it de novo, starting from the beginning, new, making their own determination. Now they're looking at this to determine only for an abuse of discretion, which, the judge now gets a lot of discretion. And so it's a different standard that they're looking at. Here, the defendant concedes that the affidavits do not indicate exposure to extraneous matter or juror bias that would suggest her right to an impartial jury was compromised, citing a Massachusetts case, McCaleb. Instead, she argues that the affidavits suggest an, quote, unannounced verdict, warranting further inquiry. Yet, as discussed, a verdict, as a matter of law, requires a public announcement in open court. No verdict exists if none was announced or even intended to be announced by the juror before the jury before they were discharged. Citing Brown, a Massachusetts case, 2015. Once a jury has been discharged, they have no further power to deliberate or to agree to a verdict. I'll finish it up here. I think this is the last page or two. Allowing inquiry into private agreement reached in the secrecy of the deliberations room would also contravene our prohibition on probing the context of juror deliberations. Maintaining the secrecy of those deliberations is a, quote, bedrock of our judicial system, quoting a 2016 Mass case. Also Woodward v. Levitt from 1871. It not only prevents jury tampering, but also upholds the finality of jury verdicts and fosters confidence in the judicial system. Quoting to Massachusetts case Fiddler, 1979. Probing secret deliberations to determine whether the jurors may have privately agreed on a verdict they never returned would undermine these fundamental principles. Citing Woodward again, juror testimony as to, quote, part of which he or she took in discussion and votes of the jury is not permissible because it relates to the private deliberations of the juror. They also cite to a Florida case for the proposition that even though post-discharge inquiry asked jurors to, quote, disavow the non-existence of a verdict rather than to impeach a verdict already in existence, is still constituted improper inquiry into the jurors' mental processes. So, and that was a distinction I was trying to make earlier, with which the court is here saying, nope, too bad, too sad. It still constituted improper inquiry as to the jurors' mental processes. Sorry, I said that already. Were it otherwise, quote, jurors would be harassed and beset by the defeated party in an effort to secure from them evidence of facts that might be used to set aside a final verdict. Again, citing Fiddler. Nor is the defendant merely seeking juror
On the roof?
Yes.
Oh.
Nor is the defendant merely seeking juror testimony as to a, quote, mistake entered on the final verdict slip, citing the Massachusetts General Evidence Rule 606C, permitting juror testimony about mistakes, quote, made in entering the verdict on the verdict form. Here there is no suggestion that the juror's failure to return a verdict was the result of a clerical error. The post-trial accounts do not dispute that the jurors had reached an impasse, as they reported, and had decided not to return a verdict slip on any charge as occurred. And they contrast that to Brown and other cases that permitted testimony to correct clerical mistakes in verdicts where the jury, without outside influence, immediately indicated error in the announced verdict. No juror expressed surprise or disagreement in court when the judge declared a mistrial based on the jury's report that they could not reach unanimous verdict on, quote, the charges. Again, contrasting the case of Latino v. Crane in Massachusetts, 1994, where juror inquiry was permissible, where the jurors audibly answered no during polling of the jury. Additionally, the limited exception for jury testimony concerning mistake verdict only results in alteration of a verdict where there has been no, quote, opportunity for outside influence. Well, that's clearly not the case here. Again, citing Brown, also citing Commonwealth v. D. Benedetto from 2019. Here, all the defendant's affidavits concern jurors' accounts to others after learning, quote, leaving, quote, the control of the court. Oh, we're still not done here. I thought it was
Just a little bit more.
Citing to Brown and Bolden.
Hey.
U.S. and Edwards. Oh, and then also a Massachusetts case, Edwards in 76. When jury leaves, quote, the serenity of the court's control, contamination is presumed. And here, come on. The court goes on to say a post-trial inquiry of these jurors would similarly occur well after they became susceptible to outside influence and would not provide a recognized basis for altering the result of the first trial. Citing to Johnson, a Pennsylvania case from 1948, court could not alter verdict of acquittal upon learning that the jury had intended to convict defendant of a lesser offense where the jury, quote, had ample opportunity, end quote, to clarify or express disagreement with the original verdict when it was announced in open court the prior day. I've got the hiccups, so read it and you're at the conclusion anyway.
Thus, the trial judge did not err or abuse her discretion in denying the defendant's request for such an inquiry where it would not change the outcome of the defendant's first trial. The jury chose to report a deadlock, not a verdict, and no basis exists for further investigation into private discussions or subjective beliefs they declined to announce publicly in open court. Conclusion. For the reasons stated above, the trial judge correctly denied the defendant's motion to dismiss and request for a post-trial juror inquiry. The case is remanded to the county court for entry of a judgment denying the defendant's petition for relief. So ordered. So there you go.
And I know Mandy's saying it's time for me to do a cartwheel because it's over. I'm just still, I mean, I was sort of like, what the hell, raise the insufficiency of the evidence argument, before, but it's just been irking on me since I read that.
Irking. It's been
that
irking her.
footnote, like,
It's been irking on her.
I think it could have made a difference. I think the argument that it demonstrates that there was insufficient evidence to support the charge at least had legs. It at least had legs.
So, but what is the end result of that if they make that argument?
Well, I
In
think what we
terms
should
of-
do is take a break, let people digest, us digest, and we come back and do a little, question answer session, and not where we're just reading through the entire thing and kind of give some of our thoughts while everybody's got some time to digest. I think that'd be a good idea.
Okay. What time are you thinking?
I don't know, 6:00-ish.
6:00. I've got the Q&A with Murder on Songbird Road episode 6.
Oh, well, I don't know. Whenever whenever is a good time of day that you think you pick.
I don't know.
How about 4?
4. Well, that you'd like that because that would really put me on a very strict clock. I'm pretty good about keeping the.
Yeah, I mean, I don't think we need 2 hours to discuss all of this, but I'll put my thoughts together about what we kind of thought should have happened and if that would have made a difference.
Okay, so you're thinking we come back prior to the Q&A thing?
It's up to you, or we could go after. I mean, to me, it depends on, when most people are available. I was thinking what Mandy just asked as well.
It's an off night.
Today's not right. Yeah,
Right.
Tuesday.
We got Monday and Wednesdays are volleyball.
Yep,
Yeah,
I'm
so
gonna
make
feed
sure-
Bob. I'm gonna
feed
feed Bob
Bob.
now. Neither of
Bob.
us have eaten yet.
Feed Bob. Bob need food.
Oh, but we've got some questions here. Almost
Yeah, there's
forgot.
some-
So sorry, guys. Nikki, thank you for your generosity. I don't think, because this is an interlocutory appeal, so I don't think that they can raise this to the federal level. I mean, I don't practice out there, but I would assume no, that's going to have to wait till they do the regular appeal process. And then, I mean, the Supreme Court doesn't want to be dealing with stuff that might not matter because she could get found not guilty on this charge at trial, and then we didn't need to bog down the court system with it. But all of the issues can ultimately get raised to the Supreme Court after the next trial. And 40 Doherty, thank you for your generosity. Did the defense ask for a change of venue? Do you think it would have made a difference? Could they now? I think they specifically decided they wanted to stay there, but I'm not 100% sure. I don't know if you know, Bob, but I do not think it would have made a difference. And I think now, given all the other corruption and stuff that has come out in this county, stay where you're at.
Yeah,
Right?
it'd be the prosecution looking to get it out of there, not the defense, in my estimation. Yeah, I don't believe that they ever filed a change of venue. I think I don't recall that being filed at any point. Which, I mean, when the case was first, filed and she was initially charged, it wasn't this. It wasn't until few months after the initial motion to dismiss, wherein they kind of laid out the whole conspiracy theory that came out, that this case really started picking up steam nationally. So, at
A
that
lot
point,
more has come out about it since.
oh yeah, for
Yeah.
sure.
So, but thanks for your generosity, Lisa. Thank you for your generosity and for your offer to try and grab some tickets. But as of today, any decent tickets were gone on the pre-sale by the time I was saying that. But thank you for your
Wait,
generosity.
did you have to pay $50 to try to get a
I'll
pre?
explain it to you afterwards.
It
Not on the
angers
live.
me. That what a sleaze bag move by
I
the
mean,
what a
there's a couple
money
things
grab.
we were talking about that. I'm like, what the hell is this all of a sudden? And then call it one big family after you just charged us.
Stole our boy's shit. Yeah. Um. Yeah,
Should have an asterisk again anytime they say use one
I
big
think
family and say Garrett and Shay Miller.
Federer's got a serious conflict when he decided to represent Aiden. I don't know that would work. That he
Is that
joined.
really is she saying that that's actually happening?
I don't know, but
I'll have to ask Melanie.
yeah, we'll ask Melanie. That sounds like a conflict city to
Why
me.
is it a conflict? You just know
Because
more than I know. What did he do?
well, it's alleged that Aiden and
Oh, he
Karen were in cahoots to, that it was a concerted effort by them to, bully the witnesses and intimidate the witnesses in the case. It's like,
I don't see.
it's very intertwined. I don't know how you don't see it's a conflict.
Well, I just not for the purposes of the retrial. Now, if she was being charged with something related to the witnesses, sure, absolutely. But I don't see it here.
You
But
know,
but I have to think about it more. We'll find
I
out
can
if it's true.
guarantee
We'll
you,
discuss it
Brennan.
when we come back.
Brennan would definitely be filing a motion trying to boot him. I guarantee you that. It's very intertwined. It's very, very intertwined. It's like you can't one does have something to do with the other. They're not.
Well, I know, but that's not what there's no charge of that, pending, and it doesn't even matter about.
Oh, she says it's on the docket this morning. As of
Oh, so I
we'll
guess
find
we will
out.
see.
We'll find out if Brennan's going to try to boot him. So, I mean, that ends Bettero's YouTube career on talking about the case. So,
well, until afterwards.
until afterwards, yeah.
He's all right.
So, all right, we will figure out what time we want to come back. I'm sure Allie's going to do a little digging in the law and try to come up with some tasty nuggets. So we will figure out. Yeah, that makes sense, Andrea. Once you're signed on to a case, that ends your discussion publicly about it. So,
well, yeah, under the rules, he can't talk about it publicly anymore.
Spoogies, you're way late. You're way late, Spoogs. Spoogies, way late. All right, so
we're coming back, so you can see us later, Spoogies.
Yep, Spoogies, we're coming back probably around 4. I'm going to confirm with Lauren she's available for the Q&A on Murder on Songbird Road at 5. So you'll have a couple solid hours there, and we will continue this discussion. I'm not surprised. I'll just end it by this. I'm not surprised. You're basically asking the court to create new law, essentially here. I mean, this is pretty well established law in terms of what they hung their hat on. And at the end of the day, I think that there was just nothing compelling enough that was going to have them change the law on it. That being said, I still think it's a horrific mistake for the state to continue to proceed on that
First
second degree
degree.
murder, the second degree murder charge. It's crazy. It's crazy. It's crazy.
Agreed.
It's crazy charge. So, all right, y'all. Thank you, mods. We love
Thank
you.
you, mods.
And you guys, we love you as well. Thank you for your generosity. And we will see you later in the day, because without y'all, I'm just an old man
Talking about a lot of cases.